Former President Jacob Zuma is back in court in his bid to appeal the dismissal of his special plea judgment not to recuse advocate Dubazana. In the application, Zuma's counsel questioned the impartiality of the lead arms deal prosecutor. Zuma and French arms company Thales are in the spotlight over allegations regarding the controversial multi-billion-rand arms deal in the 1990s. We get a sense of why some court matters take so long to go to trial. We are joined by Nthabiseng Dubazana from Dubazana Attorneys. Thank you very much for joining us, and thank you very much for your patience. Perhaps let's start with this concept of awaiting trial. I think two high-profile cases that come to mind is that of Nomia Ndlovu, who waited some 3 years before her matter went to trial. The Tulsi twins, they've now been arrested for some 5 years awaiting trial. This concept of awaiting trial, what does it mean, and also why does it take so long?
The concept of awaiting trial basically means that you are waiting for the state to get its house in order. So we are waiting for investigations to be concluded. We are waiting for anything that is going to be done pre-trial. So in other words, once an investigation is done and concluded, no matter how long it takes, this is the process of me as a defense attorney receiving the copies of the docket from the state. And after having perused all of that and gone for consultation with my client, it may lead to other things that need to be done pre-trial starting. So things like representations for maybe the matter to be removed from the roll because there's not sufficient evidence for the state to prosecute on, or perhaps having found technicalities that the state did not adhere to that will make their case null and void. So those things are a cumulative amount of things that happen that delay a trial, which also leads to what we just call awaiting trial, like you just said.
So in the case of the Tulsi twins, for instance, spending 5 years behind bars awaiting trial, this essentially means what really for their case? I hear you speak of, the state getting its house in order. Does this essentially mean they have already served a bit of time?
That's what we would argue as defense attorneys. So what would happen in such a case once the trial does eventually get going? If they are found guilty of the offense that they're charged with, then we would argue in the mitigation of sentence that the 5 years they spent in prison should be added to whatever sentence that will be given. So if they're given 15 years, for example, then the court consider those 5 years and reduce it from 15 to 10 years instead. But with this case, I am aware that there is a Supreme Court of Appeal case that is pending because the defense attorneys are of the opinion that the state's case is lacking, and they had made an application in that effect. So we are dealing with basically two sets of cases in a manner of speaking, because the trial itself hasn't started, but there's a case in the civil court, in the Supreme Court of Appeal, I beg your pardon, whereby the defense attorneys are trying to have the decision that was made or overruled.
Nthabiseng, unfortunately, our connection is quite sporadic, so we are losing you here and there. Let's just try and pick up on your thought on. I understand you're back with us. If you could please pick up on your point.
So we are just waiting to see what is going to happen with regard to the SCA case, and then we'll see how it will affect the criminal trial case. So we're looking at the possibility that if the SCA case overrules what was said by the court of court, which is the court that's going to hear the trial in any event, then this case might not even proceed. But if the SCA confirms what the court of court said, then we are looking at the trial having will commence as a result of that outcome.
Is it fair to make comparisons perhaps between what we are seeing play itself out at the Pietermaritzburg High Court for President Jacob Zuma, his appeal today that he brought before the court, and an unknown, right? So somebody who is not high profile, whose cases that we don't know about, somebody who has been waiting 8 years, if there is such instances. What does this speak to? Is it an affordability issue where somebody who cannot afford to take a matter on for years then spends so much time behind bars while the state tries to get its house in order?
It's not about affordability. I just think it's the under-resourced NPA, unfortunately, and sometimes also the under-resourced SAPS, because remember, investigations are not done by the NPA, they are done by the SAPS. So they can only do so much. And then the NPA now has to look at the evidence before them and see if there's any merit to it. But when you're understaffed and overworked, sometimes you do miss certain things. So when it comes to myself as a defense attorney receiving that docket, whether I am an affordable attorney or not affordable attorney, if I can pick up on those things, I will try and get you help as the accused so that you don't go to trial. But that only relies on how much work the NPA and the SAPS can do. It is unfortunately the stance of so many other cases that are standing still and not going anywhere because of lack of evidence. But also sometimes we as defense attorneys do fail our clients. When such a case is taking so long, we have the right to request the matter to be removed from the roll by using section 342A, for example, of the Criminal Procedure Act, and having the matter struck off the roll until the state is ready to proceed with the matter. But sometimes I don't know why we don't invoke that one, because it's such an easy step to do. But that's the route to go. If you're not ready as the state, remove the matter from the roll, bring it back again when you're ready and you're done with your investigations.